asked to stop APC primaries over implementation of Section 84(12). Welcome to the news and please subscribe to our channel. To get notified when we post hot juicy news updates, please click on the notification bell. The chieftain of the All Progressive Congress APC, Chief Ifechukwu Ene, has dragged the party before a high court of the Federal Capital Territory, asking it to nullify, set aside and invalidate any convention or congress of the party for the purpose of nomination of its candidate for the 2023 general elections over the implementation of Section 84(12) of the Electoral Act. Already, some states controlled by the party have been issuing directives to its members and political appointees seeking to contest elective offices in the 2023 polls under its platform, who were still holding political offices, to vacate or resign in compliance with the now nullified Section 84(12) of the Electoral Act 2022. The suit marked CV 1297-2022, dated April 21st, 2022, was filed on behalf of Chief Ene by his lawyer, A.G. Iteun ESQ. The AP says so defendants in the suit instituted by way of an originating summons. Specifically, the plaintiff wants a declaration that the active conduct of the APC in directing and mandating all members of the party or political appointees seeking to contest for elective offices in the 2023 polls under a platform, who are still holding political offices, to vacate or resign their political appointment in obeisance or compliance with the now nullified Section 84(12) of the Electoral Act 2022 is illegal, unlawful, unconstitutional, and therefore null and void in its entirety. The plaintiff is also seeking a declaration that all or any member of the All Progressive Congress APC or any political appointee seeking to contest for an election under the platform of the party and having met the requisite constitutional requirement for any elective office cannot be mandated, ordered or directed to vacate or resign his political appointment, or by that fact deny the right to vote or be voted for at the convention or congress of the party for the purpose of nomination of such candidate for the 2023 polls, in so far as the person resigns or withdraws from his appointment at least 30 days before the date of election. A declaration that the defendant cannot validly or lawfully create or impose additional requirements or qualifications for eligibility for any person seeking to contest for any elective office in the 2023 general election under the platform of the party, other than the constitutional requirements of qualifications imposed or created by the Constitution of the Federal Republic of Nigeria or any other law enforced in Nigeria. Another, setting aside, nullifying and or invalidating the directive of the defendant mandating, ordering or directing all or any member of the defendant or any political appointee seeking to contest for an election under the platform of the party to vacate or resign his political appointment for the purpose of nomination of such candidate for the 2023 general elections. An injunction restraining the defendant, whether by itself, agents, nominees, members, officers, representatives, or whoever prescribed from denying all or any member of the political or of the party or any political appointee seeking to contest for an election under the platform of the party the right to vote or be voted for at the convention or congress of the defendant for the purpose of nomination of such candidate for the 2023 general elections, insofar as the person resigns or withdraws from his appointment at least 30 days before the date of election. Another, nullifying, setting aside and invalidating any convention of Congress of defendant for the purpose of nomination of its candidate for the 2023 general elections conducted, organized, or carried out wherein all or any member of the party or any political appointee seeking to contest for an election under the platform of the party is excluded or denied the right to vote or be voted, despite the person having validly resigned or withdrew from his political appointment at least 30 days before the date of election. Before seeking the relief, the plaintiff had asked the court to determine whether, by the combined effect of Section 40, 42, 66, 1F, 1071G, 1371G, and 1821G of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and Articles 2, 9.1I and 9.3I of the Constitution of the All Progressive Congress, 2014, as amended. The Act of Conduct of the defendant as expressed in his directive, mandating all members of the party or political appointees seeking to contest for elective offices in the 2023 general elections under the platform of the party who are still holding political offices to vacate or resign their political appointment in obeisance or compliance with the now nullified Section 8412 of the Electoral Act 2022 is not illegal, unlawful, unconstitutional, and therefore null and void in its entirety, whether by the combined effect of the Section 40, 42, 66 1F, 107 1G, 147 1G, and 182 1G of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and Articles 2, 9.1I and 9.3I of the Constitution of the All Progressive Congress, 2014, as amended. All or any member of the defendant or any political appointee seeking to contest for an election under the platform of the party and having met the requisite constitutional requirement for an elective office can be mandated, ordered, or directed to vacate or resign his political appointment, or by that fact deny the right to vote or to be voted for at the convention or congress of the defendant for the purpose of nomination of such candidate for the 2023 general elections for as the person resigns or withdraws from his appointment at least 30 days before the date of election. The suit is yet to be assigned to a judge. Things are not looking funny at all. This is shameless. Pretty people masquerading as an APC member. They should tell his paymaster that there is a substituting judgment in favor of those who haven't responded to the self-service Section 8412 unconstitutional insertion by NASS. He should tell his paymaster that the 1999 CFRN as amended Constitution of the Federal Republic of Nigeria directs such person to resign 30 days to election and nothing more retentions. The shameless PDP should rather be suing us for an infraction on the supreme law of the land, the Constitution of the Federal Republic of Nigeria, instead of embarrassing himself and his family and the cause chasing shadows. Well, I was going to ask before, this particular section was just signed into law recently, was passed into law. The bill was passed into law. And I was like, are they not going to follow it or not? Well, we'll watch and see how things unfold. On this note, we have come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.